Good morning. I'm Paul Truster, Program Planning Lawyer with the Department of Continuing Legal Education of the Law Society. On behalf of the department, I'd like to welcome you to today's program, Getting the Facts Fast and Cheaply, a program for litigators. I'll begin by thanking our volunteer faculty, not all of whom are in place yet, but as I'm sure you know, CLE is completely dependent upon the efforts of our volunteer faculty who have given very generously of their time and talents, both in preparing for this program and in presenting it, and we're deeply grateful to all of them. No further ado, I'd like to introduce today's chair, Harvey Bliss, Queen's Counsel since 1978, trial and appellate counsel at Bliss & Associates in Toronto, has served as an instructor in trial practice at Osgoode Hall Law School and in the bar admission course, and has lectured at Law Society continuing legal education programs as well. And you'll see from the biography in the enclosed material that he's held various executive positions for the Canadian Bar Association of Ontario, including chairman of the National Executive Subcommittee on Legislation and Law Reform. Please join me in welcoming Harvey Bliss. Thank you.
Thanks, Paul. As you'll see from the printed material, we start off by describing what this program is not. It is not everything from the first interview down to trial. It is not trial preparation as such, that is, after the case is set down, getting ready for the actual trial. It's not settlement or pretrial as settlement. We'll be dealing with pretrial from the factual point of view, that is narrowing the issues. It's not legal research, although we'll be dealing with legal research in the context of our program, which is fact-oriented. Most cases turn on facts. You don't learn enough about facts at law school. You get a rather distorted view of what law is all about at law school, that is that what is important is legal principles. But in the hard practice of clients coming in your door and wanting solutions, the most important thing is determining the facts. And the huge job, often huge job, of gathering them and marshalling them, analyzing them and narrowing them. Often you don't succeed. The objective is to try to get all the salient facts, put them together in some sort of comprehensive fashion, try to get agreement from the other side, either on consent or through the court process, as to what the facts are, and ideally virtually go to trial on an agreed set of facts. Never happens. It is so rare that you can actually get an agreed set of facts to try a case on. You often also fail in trying to get a judge or a master to force the other side to cough up documents, to agree on facts, to answer questions on discovery. And we're going to hear from one of the judges today who's most successful in knocking heads together on what the court can do to narrow the facts, having regard to the limitations of the system, that is the variation from judge to judge. And I think he might be frank about that. So we're going to talk today about techniques for identifying, gathering, narrowing the facts, which hopefully will apply to either a complex or a simple case. What we're talking today about is a comparative lessening of cost, not an absolute lessening of cost. The more complex the case, the bigger the case, the more expensive it's going to be. The most you can do is to try to reduce the cost to a minimum. Litigation is not cheap, can't be cheap. What we're trying to do is to give you techniques to make them as cheap as possible for the client. And knowing the structure of a simple case, a simple fender bender, learning the steps A, B, C, D, E, will then help you to apply those techniques to a more complicated case. Learning how to handle a complex case will show you how to apply those techniques to a very simple skeleton of a simple case. And I give you an example of the case where you know you've got three key witnesses. Now, you either go to trial with those three key witnesses, or you do what I do. You search the file, you search your investigations, you search your client for every conceivable witness, and you end up with a list of 50 witnesses. And then you decide, of those 50 witnesses, who am I going to call? And you may end up with 3 or 5 witnesses, and they may be the same 3 witnesses that were obvious from the beginning, but not necessarily so. And I don't feel you can take the chance on going to trial with those first 3 witnesses until you've gone through the larger exercise. And I apply that analogy throughout the preparation of a lawsuit. You've got to at least perceive the complexity of the case. You've got to make a 5-page list of issues, but then a half-page thrust. You want to know all the issues that will possibly arise, because any counsel will tell you they've been to court many times in which the judge has had a different perception of the most important issue or the 3 key issues that you have. I was once arguing an insurance appeal, and I went to a civil litigation meeting at which Justice Aylesworth, late of the Court of Appeal, was speaking, and he said, throw away extraneous points. Go to the appeal with your 3 key points. And I had 4 points, and I dropped my 4th point, and I went to the appeal with the 3, and of course the 4th they wanted to hear. So as smart as you think you are, you can't foresee. So always maintain the flexibility to be aware of the other points that may arise. You're obviously not going to spend as much of your client's money preparing those what you think are marginal points, but you got to be ready. You don't want to be caught by surprise when the judge looks down at you and says, Miss X, isn't the key point in the case this? And you haven't even thought about it. Litigation is, in many cases, too expensive. Small claims work in the sense that $3,000 to $5,000 cases can't afford a lawyer. A $10,000 case can't afford a lawyer. A $25,000 case can't afford a lawyer. So if you take on a case of $25,000 or $50,000, you may feel obliged to prepare that case disproportionately out of a sense of professionalism. And every lawyer does this. You do work in preparing a case that you know you're not going to be able to charge for. You defer the work until it has to be done. You don't prepare the trial until you know you can't settle and it's going to trial. But when the point is reached where work has to be done out of your sense of professionalism, that you don't dare walk into court and get embarrassed, then you're going to do more work than the case demands, more than you could assess, and not be able to charge for it. I mean, that's just part of the nature of the practice. But the question is, what is the minimum amount of work that you have to do, and who does it? Who does it most effectively? Large cases can demand thousands of hours of work. There are a lot of people, if you've never been involved in a large case, and unfortunately many assessing officers have not, and many judges have not, you don't appreciate that a large, complex case can demand thousands of hours of work. And stated simply, it may seem astounding, but when you're into it, you see the kind of work that's involved. Well, whether small or large, how do you do it? How do you prepare? How do you gather and marshal the facts? And how do you do it most efficiently and most cheaply? I'm going to take you through the first step, the intake and the first interview, and then we'll go on with Cliff Shnier on computer programs, and you've got the program, and I don't have to tell you now what's facing you during the day. There's been a change in order in that Bob Armstrong, who was supposed to deal with production in the logical flow of things, is on trial, and will be here at the end of the day. So turning to my first paper on intake, first interview, production, internal production, not production from the opponent, gathering facts and building a file, subtitled What to Look For, How Do You Get Documents, and How Do You Get Facts Not in Documents, Delegating, Organizing, Briefing, My system is to have a system in place before the first call from the client. Consider what you want to do. If you've got a small practice, it may be that you take all the calls. I don't. We'll come to my system, but what are the considerations? Are you going to take all the calls? Do you pick up the phone, or does your secretary screen them, or do you have voicemail so you know what it is, something about it before you call back? Does your secretary screen out all the junk calls, the salespeople, the cases you don't call, it's not something you do? What do you want to learn from that first call? Do you want to meet the client first, or do you want to read up first? Do you want to have a quick look at the law, think about what you want? Do you want the client to do some briefing for you before the client comes in? And what does that mean? Can you create a standard list of documents that you want from clients in matrimonial case, commercial case, motor vehicle case? How long should the first meeting be? Is it a short eyeball meeting, or are you going to spend 10 hours at that first meeting gathering all the facts? If there are boxes of documents to review, and it's going to take 10, 15, 50, 100 hours, who's going to do that? Are you going to do that at your rates? And I used to, as a fresh junior, I used to spend 10, 12 hours doing that first go-around of going through the documents, which are always out of order, and putting them in order and deciding what the skeleton of the case is and what else there is. Do you have a staff? Do you have trained secretaries and litigation clerks to do all or part of that? And do you want to, or do you want to do it yourself? So this is what I do. You don't have to do what I do, but I'm simply telling you what I do, and use it, use part of it, reject it, whatever you want. I never take calls. I never take the first call. My secretary screens my calls because a lot of them are salespeople. Fully a third of the calls that come in are stockbrokers and whatever. So she screens it, and she sees, first of all, if it's a client, if it's the type of work I do, and if it is, she'll get some statistics. And this is a hard-earned lesson. I still sometimes forget to take my client's telephone number, and I can't call them back. Or I don't have an address, I can't write to them. I'm stuck waiting for them to call me again. So you want a system set up that your client will get some of those statistics on that first call, name, address, telephone, fax. And then, if she's through that preliminary screening, and some clients are cooperative and some clients resist and don't want to talk to a secretary, and that's fine, then you have to take it. But to the extent that first call can be screened, it saves you a lot of work. So then she hands the note to me. I've got a name, I've got a telephone number, I've got something, short nature of the case. I don't sound dumb when I first pick up the phone. I know something about it. So you take the call and you ask some further questions. You try to find out something more about the case, and inevitably you'll be able to get more information than the secretary can. What's the status of it? Is it prospective litigation, or is it a motion returnable tomorrow? Are you free tomorrow? Can you take this case? Preliminary look at conflict. Have you acted for any of the parties, and so on. Insurance, if it's applicable, if it's a case that might be covered by insurance, you want to know right away, has the client thought of notifying the insurance company, who will appoint a lawyer? You're not going to get that case. And then the key point, to me, the preliminary instructions to the client to do the work. Now, this is my system. I try to get the client to do as much work as possible. That saves the client money. And if you explain to the client, the more you do, the less I have to charge you. Most of them appreciate the need for them to do it. A lot can't. A lot just aren't capable. Most business people can. They've got the techniques, or they've got a staff who can do it. I tell them, gather the documents, and we discuss what the key documents are. There'll always be more. put them in chronological order. I mean, it really saves you time if the documents come already in some sort of order. Do a first draft chronology, and I'm going to come back to this because the chronology is the backbone to my system. If the client can give me a brief, handwritten, typed if they can, dictated, disk, whatever, of the facts in a chronological order, which I then convert to my chronology, a net worth statement, if applicable, a one-pager, assets and liabilities, and the backup documents, the title documents, and so on. Then information for searches. If the client doesn't have information, I know my husband has got a property in Richmond Hill and such, you get as much information as you can, and you send a clerk out to do sub-searches. You try to get as much information as you can, hopefully before the first interview. When the client comes in, you know more about the case than the client does. Cash retainer, I mean, there are those cases where you've got to talk about how much the case is going to cost and how much you need up front. The corporate pyramid, addresses and telephone numbers. You know, this you supplement what the client has given your secretary, and it's crucial. In every case I've got on the inside cover of my file, everywhere I can contact my client. Car phone, fax, everything, cottage telephone number. There will be cases in every case where you're desperate to reach your client and you can't. So get every contact place where they might be. Mundane, but important. And have the work done at as low a level as possible. Cheapest if the client does it. What staff does the client have to help them? Does the client have an accountant who can help them? Often does. Have them do it. Are you going to retain an outside forensic accountant, which I try to do as soon as possible if it's that kind of case. In a matrimonial case, I try to have the accountant draw the financial statements. I can do it. I have done it. I'd rather have an accountant do it. And any other experts that have to be brought in at an early stage. So the client staff, outside staff, and then in your office, a trained litigation secretary, a litigation clerk whose rates are lower than yours, a junior if you're a senior, and last of all you. If you're a senior, you're the last person to be spending a lot of time on the file. Your rates are too high to do anything but supervise, take the key steps, motions, discoveries, and so on, but you try to delegate work to it at the lowest level as possible. So before the first interview, if possible, I try to get as much done as possible. I try to get the client to send in the documents, the chronology. I have a secretary or a clerk review them and put them together before the first interview, if possible. So when the client comes in, I can talk about the case intelligently. Doesn't always work. Sometimes you've got to meet the client right away. Sometimes the client is window shopping. They're interviewing 8 lawyers and they just want to come in and eyeball you, and fine, you've got to do that. In the cases where it can happen, the client wants you, you've decided to take the case, I try to get as much work done as possible before the client comes in. So then the client comes in and you eyeball each other. You're going to have to live together for 3 years. You want to make sure you can, and sometimes you decide you can't act for that client for those eyeball reasons, or the client doesn't click with you. You review the documents, the facts, you give them direction as to what more you want brought in. And that first interview is short with you. You may then turn the client over to a secretary or junior to do further work. More and more lawyers are having in-house social workers for matrimonial cases to handhold the client, to work through the financial statements, to do a huge, tedious job of gathering household bills and so on. No way a lawyer should be involved in reviewing household bills. You may have to. You get some guidelines as to how much this case is going to cost. What is the budget? Is it a case that there's millions of dollars involved and there's no holds barred? the fee's going to be $500,000 and do your best? Or is it, look, this is important, but there's only $200,000 involved, and I can't spend more than $40,000 in legal fees and so on. You've got to have those general guidelines. Consider a written retainer. Authorizations if you need them. First interview. Are you going to need hospital and medical reports? Signed authorizations. Do you have to get tax returns from Revenue Canada because your client doesn't have them? Signed authorization. Avoid giving preliminary opinions at that very sketchy stage, but you might have to. Then letter to the client. Having seen what the client has brought in, either before, and sometimes you get cases, you get a first phone call, the client's going away 3 weeks, you've got luxury to do searches and send a letter out to the client. At whatever stage, consider whether you can send a letter to the client, and I've given you an example, a precedent at the end of the printed lecture, letter to the client with a summary of all the stuff I want from them. Just a precedent, you've got to adapt it. It'll vary depending on whether it's a matrimonial case or a commercial case or a personal injury case or whatever, but I have a precedent letter on disk, and my secretary can give me the first draft of the letter. And my secretary, in addition to just printing this one out, can adapt it. My secretary will editorialize the precedent, put in the client's name and address, and adapt it to the facts of this case, whether it's a male spouse, a female spouse, whatever, and give me a fairly good draft, which I then review with my knowledge of the case and finalize and send out. Now that partly my to-do list, which we'll come to, my script for what I'm waiting for from the client. I find it useful in a lot of cases. It helps if you've got it on computer and you can print it out, and your system produces a first draft, which saves you a lot of time. If at that stage I've got the preliminary chronology drafted, which I may have by the time that letter goes out, then I send the chronology out to the client. And I do that several times. As I gather more information, I send out updated chronologies to the client for further inputting. I draw a to-do list, which is the next document you'll see at the end. From the beginning of the case, I have a to-do list, everything I've got to do. The searches, the pleadings, the next steps in the litigation. I've got a trial preparation to-do list too, which is not here, but it's 5 pages long, all the steps in trial preparation. But this would be like my second or third to-do list. I've already done some searches, perhaps, so they're not on this list. It's just a tickler, a reminder for me, for the other parts, the other members of the team working on the staff, the secretary, the clerk, the junior, whatever. I find it useful, you may not. Opening the file, getting the correct name of the parties, making sure the accounting department has got the correct name, make sure the correct name goes on all dockets and memos. Amazing how often memos get misfiled in the wrong file. Just the heading on all the pieces of paper to make sure it's file A and not file X. Simple stuff, but you sometimes forget. List of searches. You want to have in your office a list like this that's just a memory tickler of the possible places you may want to have searches made for information. And then keeping the searches. I tend to put the searches in separate folders. If I'm searching 5 separate properties, I have a separate subfolder for each property, and you'll see how we deal with that when it comes to the affidavit of documents. Point 9, transfer work from the to-do list to the done list. it's amazing how often I have a brilliant idea of a search I want done, and I've already done it. And as you get older, you'll find that happens more and more. So I keep a done list. Sometimes it's the same list. Sometimes it's a list with to do in the left column and done in the right column. If, for example, you've got 20 properties to search, on the same page you'll know which ones the searches have come in and which ones you're still waiting for or whatever. Point 10, you get in from the client the balance of the documents you've been asking for, the facts not in the documents, telephone calls, meetings. Then we add to the chronology. You've got to have a database, and you'll be hearing further about what database you use, and making the systems compatible, because you know you can now get disks from the examiner. You want to make sure that all the information can be coordinated and input. So as I've said, the chronology is the key to my system. The next document at the back is the chronology. And this is the way I do it. Your database may require you to do it differently. This goes into my machine. If the client's got a system and can give you a nice document like that, is it not there? You didn't get a printout of the chronology? Well, we'll have to see about that. They have the disk. Going to be hard for me to describe it. It looks like that. Chronology. Years, month, and day, a description of the document, third column, the source. You get it from the client. If the client's got a disk, you use that and you amend. In any event, I end up with my disk, which my secretary prepares using the client's chronology, the searches we've done, all the other information we've gathered, all gets input into the chronology. And then right on the chronology, I mark what's missing. If there are things I still have to get that I know, then I'll put that right in the chronology in a big bold get or something like that. And I'll send it out to the client and I'll say, this shows you the facts that I've gathered so far. Are they right? And you'll see the missing facts. Get them for me. Interoffice memos, whatever. So in that chronology, I put the documents, which are the backbone. Most cases turn on the documents. Very hard to convince a judge that something happened contrary to a written document. We all know that, so the backbone is the documents. Then the conversations, the meetings, the discussions, and so on, and the allegations and pleadings. If I'm defending and the statement of claim alleges certain things happened on a certain date, that'll go into my chronology because I can then compare the allegation against the facts I've got. And then as the case progresses, as you go through production, I've got production numbers. My production numbers go into the right column. I get the affidavit of documents, and my affidavit of documents gets pulled from the chronology. Very easy to get a first draft affidavit of documents pulled right from your chronology. When I get the opposite affidavit of documents, their number goes in. If there are several parties, many of whom are producing the same document, then I'll have a document in the chronology, and the right column, it'll have A25, B32, X97, and so on. So you can cross-reference that everybody has produced the same document, and you can see who hasn't produced a particular document. And then on discovery, that gets input again. If an answer is given on discovery, contrary to the facts as I now know them, that'll get cross-indexed into the... Kathy, can you find out what happened to the chronology? There was supposed to be a chronology in my lecture. You got the disc and it didn't get printed out as part of the material. Can you see if you can get that printed out and distributed? Thanks. So then point 13, what I call the second interview, the real interview, that may in fact be a composite of several interviews. That's a continuing process throughout where you're going through your chronology, which is a composite of all the facts you've got, and you're trying to reconcile inconsistencies and missing documents and pounding your client to give you stuff. And you often have sloppy clients, reluctant clients, recalcitrant clients that you just have to hammer repeatedly to get documents. As to marking the documents themselves, I've given you my system for marking the documents, which is very important for record keeping, for identifying the source of the documents. You've got a piece of paper in your file. In addition to having it on the chronology, you want to know from the piece of paper where it came from. Is that your production or the other side's? I'm going way over time, so I'm going to skip through. You've got the material here. Witnesses, the same thing. You get from the client, you supplement from outside sources, you make a list of clients, of witnesses, and as the case gets closer to trial, you want addresses and phone numbers so you know where to get them to summons them for trial. Statements, witness folder, list of witnesses, witness statements, which you'll need for discovery and for trial. Separate folders, briefing, obvious. I mean, any of you in the business know, but incredible the number of files that come in if you do counsel work and you get files referred from solicitors, just a jumble of pieces of paper. Everything is together, correspondence, deeds, and so on. So from the beginning, you have got a system. One folder for color-coded, green folder for correspondence, red folder for main brief, purple folder for interlocutory brief, different folder for productions, different folder for law. Memos for file. I mean, often you'll learn something important and you'll put it in the file and you won't be able to find it a year later. Make a copy and have a memo folder where you want to be able to retrieve facts. Here's the expert on retrieving facts, but whatever the system is, have a system. If the chronology becomes massive, then you've got a second chronology, which is a one-page key date chronology, just so you remember when was the contract and when was it first attacked and so on. I talk about the duty to inquire, the sorts of things that you'll want to look for, liability and quantum. Remember both. It's amazing how often you forget quantum. You get so anxious about liability, you don't pay enough attention to quantum. Affidavits of documents, I've given you here, I think you've got copied here, two basic forms of affidavits of documents. One is chronological. If the case consists mainly of correspondence, of a chronological flow, invoices you group together, but apart from that, chronologically. If you've got a file where you've got 20 different subfolders, you've got different corporations, different titles, and your productions are in subfolders, my affidavit of documents is drawn that way, with subheadings, and you'll see that in one of the precedents here. I describe what the folder is, and I describe with sub-numbers what's in the folder, and you've got a number. There have been many cases now saying you're obliged to give key identifiers, and you've got a number and sub-number. Law, real evidence, thrust and list of issues. As I said earlier, you want to think of all the issues, and I give you here a precedent for a list of issues, and it could be much longer, but then you want your thrust. You want to know what is my case? What's the essence of my case? What's the thrust of my case? So at the beginning, I draw a short thrust, which I update as my perception of the case may change. But I've always got a short one-page thrust of the case, and a longer list of issues, which are sub-issues, which can be broken down into liability, quantum, procedural, and evidentiary. Well, we'll be talking as we go through the day what happens when you run into problems. I've described how the system should work, but you get problems where you run into a lawyer for whom this is a one-way street. You've done your work, you've made mass production, you've given open discovery, and the other side has given you nothing, and you've got to bring motions for production and discovery or so on. Or you've got a client who says, I don't want you to produce that. And you say, you've got to produce it. And he says, I don't want to. And you go through that process where you hammer your client, real problem. You can't tell your opposing number the problems you're having. You got to do to your own client, but you hammer your client, techniques you use to compel him. At one point, you may have to say, look, I can't act for you. I am obliged to produce these key documents, and if you refuse to allow me to do so, get yourself another lawyer. Or you find some other way of handling the problem. I'm sorry I've gone too long. If we run into holes during the day, I may come back. Cliff Shnier is the world's expert on computer systems and is going to tell you, I've been talking to some extent about how to do this on a paper level, and I'm still computer illiterate. I got to see hard copy. But Cliff would put the paper companies out of business. Cliff never has paper. He works from his screen and never has to have a printout. I'm really jealous. Cliff?
Thanks, Harvey. We're going to have some of the lights brought down and this microphone activated. Can we have the video lights down and yeah, that's it. I think we need another bank of fluorescents turned down. All right. Are you able to read that screen? I'll stay off to the side over here. I'm using a system, by the way, called Harvard Graphics, where not only are we going to be talking about getting at the facts fast and cheaply, but also a program like Harvard Graphics allows you to present the facts fast and cheaply. Just before this program today, I put together a couple of additional graphs that I wanted to use for this presentation. It took 1 minute for each graph. Contrast that to using commercial artists to do it for you. Now, for those of you that don't know, I am a lawyer. I practiced litigation here in Toronto from the time I was called to the bar in the mid-'70s until around 1986-87 when I started litigation support consulting. And my company's called Litigation Technologies. Let me ask this audience, how many of you, and I'm assuming that you're all litigators, how many of you use computers yourselves hands-on for management of your document productions and or your transcripts in litigation? Okay, so it's about, I would say, 15 to 20% of this audience. How many of you are in firms where, if not yourself, somebody else in the firm is using a computer hands-on for that purpose? A little bit more. All right. Just to give you some idea of the extent to which the usage of computers has been accepted for management of information in litigation, we've got this study done by the Chicago Kent School of Law Center for Computers. That should say 1985 there, the little bar. 7% of all lawyers surveyed in the United States were using computers hands-on at their desk. 1992, 7 or 8 years later, it's up to 70%. We're talking here about litigators. 70% of all U.S. litigators using computers hands-on for management of documentary information and or transcript information. Now, that's individual lawyer level of the survey done of the top 500 law firms in the United States. Now, does anybody care to guess what the percentage is of those law firms that are using computers for automated litigation support? Not individual lawyers, but of the law firms where at least one or a few lawyers are using computers for litigation support in the States. The percentage, I'll show you in the next graph, a pie chart that looks like that, 100%. All of the 500 top law firms in the US are so involved. Now, just to give you some brief definitions, I'm going to have to gallop through this about as fast as a traffic reporter talks because there isn't that much time. Automated litigation support covers 3 areas now. Control of your documents. When the client brings in the documents to you, you use the genus of software known as database software for generating your affidavit of documents and getting them chronologized. It's fine to be able to take a relatively small collection of documents and either have your clerk or your client sort them in order of date to give you a document chronology. But when you've got 10,000, 15,000, 25,000 documents, that may be a bit of a burden that you can't put on your client or your clerk. We've got a client right now, and when I say a client, it's a law firm to me as a client, a law firm client in San Diego who in turn is acting on behalf of a chain of hotels that's involved in litigation where they have productions coming from San Diego, from Seattle, and from Denver, and all told it's probably going to be about 25,000, 30,000 pieces of paper. They're not sorting them in chronological order. They're getting them boxed, nicely numbered with sequential numbers on every single page, and then shipped to us for data entry into the computer, and the computer will chronologically sort them. The numbers that are being assigned to each page, by the way, are called Bates numbers. That's a brand name of a machine that applies numbers. It's not the name of a motel. And there are now bar-coded Bates numbers as well, so that at the latest stage, if you want to retrieve a document, put it up on a screen, a lawyer can pass a light pen over a barcode in a trial notebook, and it will generate the image of the document up on the screen. So, automated litigation support is information management for the documents. That's what you encounter first in litigation. Then, when you get on to the deposition transcripts, you have full-text retrieval software for searching of the transcripts. And ideally, that software should allow you to put in electronic sticky notes into the transcripts too, so you can annotate them. And finally, the icing on the cake that we now have is the ability to capture images, actual images of the documents, so that once you have scanned those documents to a digitized image, you don't have to worry about handling those documents again. They can be put off in an archive out in the suburbs. Now, the title of this program is Getting at the Facts Fast and Cheaply. I'm going to show you the next 2 charts. First of all, cheaply, and then next, fast. Here's the cheaply part. Here's a graph based on a study done by Price Waterhouse back in the 70s or 80s, where it shows that at the beginning, the amount of cost that goes into managing a litigation matter that is automated is a bit higher. You can see the chart that has dots on it as opposed to X's on it starts off, the bar that has dots on it starts off a little bit higher because there is some information input that has to go into the computer system. But by the time you've reached the examination for discovery stage, the lines intersect, and by the end of the case, the amount that has been expended on managing a litigation matter with the automatic technique is significantly less than the amount in the manual technique. So more dollars up front in automated, but many more dollars saved in the final analysis using automated. And I've got an anecdote in my written materials about an Alberta lawyer up against another law firm, the Alberta lawyer using automated litigation support, the other side not using it, and huge disparities in the bills of cost that they presented. Now, one of the reasons for such savings is the amount of time it takes to retrieve the information when you've got it computerized. This bar chart here is a logarithmic scale. Price Waterhouse did a test, sent a group of paralegals into a room where there were 10,000 documents and told them, find the documents that are written by a certain author on a certain subject. It was known in advance that there were 20 such documents. It took the paralegals 67 paralegal hours in total to come out with 15 of the 20. In other words, they were only batting 3 out of 4. It took the computer 4 seconds to find all 20. Now, that bar there showing you the 4 seconds next to the 67 hours is not, of course, to scale because it's a logarithmic scale where every increment on the taller bar is 10 times as much as the previous one, much like the Richter scale for earthquakes. So there is a tremendous amount of potential time saving involved when you get the information into the computer. Now, to give you an idea of the forest before we start looking at the trees, litigation support software categories break into 3 branches down across the... Oh, I hit the key twice. We're into document control there, but the first screen that I showed you before, I'll just give you a verbal description. The litigation support software categories are document control, and we're taking a closer look at the trees under that right now. The second category is full text for retrieval of information from transcripts. And the third category is a hybrid that combines document control and full text. Now, in document control, we've got 2 branches, those that are specifically written for litigation and those that are generic database programs. There's some brand names listed beneath that. It's not exhaustive, but they are some of the leading brand names that are known out there. I've got them in the materials, the written materials as well. That's the document control branch. Then the full text retrieval branch, again, splits into 2, litigation-specific software and generic text search software. And again, the leading brand names are shown below that. Then over into the integrated type, where you get both rolled into one, we have those that are fully functional integrated programs and those that somehow manage to achieve integration, which I call pseudo-integration. Again, certain brand names shown below, also in the materials. And if you want to make notes about that, you just note them in the margin of your materials.
I think most may be missing from the materials as well.
Okay. This would be missing from the materials? Okay. Well, all right. There's criteria in the materials about this, and certainly this isn't a seminar intended to tout any particular brand. The key thing, which I'll be getting into in the next several screens and is definitely in the materials, is criteria that you want to use for judging whether a particular software package is going to meet your needs. The leading brand names are going to come up next in the next couple of screens too, so you can catch them as we go through them. Now, here are, in fact, the top 5 programs used in the US for litigation support database management. And the names, the percentage that is the highest is the product called InMagic with 33.1%. Generic database program called Paradox is also commonly used. Also DBase, commonly used. Now, some of these Paradox and DBase may require some custom programming by a specialist before you can actually use it. Likewise, Q&A, also a generic program. Those on the left are the generic programs. And then InMagic, which had the highest percentage, and then Summation, which is also a litigation-specific program with 24.4%. Now, if you add up those percentages, they come to more than 100 because many law firms use more than one program. So those are the leading brand names, litigation-specific, InMagic and Summation, generic that get used for litigation with some customization, Paradox, DBase, and Q&A. Over in the full text world, the pie slices up not quite so equally. The leading product is called Discovery ZX. It has a very large share of the market for the simple reason that it has been handed out for free for a number of years. It's very easy to penetrate the market that way. The catch is that you have to pay the court reporting services a special premium to have the transcripts in the special proprietary Discovery ZX format. The next leading product is Summation. It's an integrated product, so it has both a full text side and a database side with 21.3%. And then we have CatLinks, Folio Views, and Zyindex with roughly the last third of the slice of the pie. Now, to choose litigation support software for databases, there are certain key criteria. I've got about 20 listed in the materials. I'm just giving you 4 or 5 up here. It's important that the structure be user definable because cases differ. That is, you've got to be able to design your database structure for your documents to meet your needs from case to case or from firm to firm. It's important as well that within any particular field of information you can have multiple entries. That is, if there's a recipient field and there are 3 recipients, Abel, Baker, and Charlie, the software has to be able to handle that as opposed to forcing you just to put in 1 entry or separate them by commas. And with multiple entry fields, you have to have the ability for what's called exploded sorting, meaning that if you're sorting your data by recipient to show which recipients received certain documents, you want to have that document that went to Abel, Baker, and Charlie showing up 3 times under those 3 different places. And there must be a variety of quality control and speed entry features to get the data in accurately and quickly. And generic database programs frequently lack these. Litigation-specific programs will likely have them. Full-text litigation support software is appropriate on your transcripts and for expert reports and pleadings. Full-text means that you're taking the actual full-text material and searching it. It's not appropriate for the documents themselves. I've had a lot of lawyers say to me, wouldn't it be great if you could just take these boxes full of productions here and run them through a really super excellent scanning machine that converts it to text, and then we just search the text. We don't have to have anybody keying in the Bates number on the document, and the date, and the author, and the recipient, and the title, and subject matter, and stuff like that. Well, it doesn't work. You can't rely on the full text for the documents nearly to the extent that you can rely on the full text for the transcripts. And the reason for this is that within the documents, the likelihood is that if you're looking for the documents talking about the automobile, you're going to miss 80% of them because they use the word Chevrolet or vehicle instead. You can't select documents by their date because the software has no ability to zero in on a specific spot and say, hey, that's the date of the document. It just knows that it'll see something that looks like a date, but it doesn't select by date. It doesn't sort by date. You can't search for something written by the author Smith because it's just going to be able to search for the name Smith no matter where it appears in a document. And there really is no such thing as a super excellent optical character recognition system that's going to be able to read those documents and convert them to text inexpensively. It's in your dreams. It doesn't happen. The technology just isn't there yet. And finally, full text does not show you what the actual document looks like. If there's a handwritten note across a document, that may be the most important part about the document. Full text won't show you that. Imaging will. You're going to see imaging shortly. Now, having said that about full text software, you still need it for your transcripts, your expert reports, and so forth, where the language is consistent and reliable. And it's important that you select full text retrieval software that's going to permit you to use standard ASCII text, because that's what most of the court reporters are going to be able to give you. And it's got to allow electronic annotating. Put in annotations to enhance the full text so you can flag it electronically the same way you do with transcripts now with Post-it notes. Now, generally speaking, litigation support software has to allow multi-user capability. If you've got a complex case, you've probably got more than one person working on it. It's got to be easy to use, menu-driven. There should be toll-free user support. In other words, somebody should be there at the other end of an 800 number to answer your questions. And it should be periodically updated, meaning the company that makes it is not asleep at the switch. Now, let's say you've got 15 boxes of documents from your client. And normally, in the scheme of things, this is an abnormal case. Normally, you might have a few dozen or a few hundred productions at most, but you got a big case, 15 boxes full. How are you going to get that information into the computer database? Well, you can do it with your own in-house resources. You might have to hire extra people, extra temps, extra space, extra machines. If you've got them properly supervised and you've got some expert advice as to how to do it, go ahead and give it a try. But there are pitfalls to it, and it's certainly not the sort of thing that you want to try for a first time without some guidance. The pitfalls that we've seen is this, that if you try to use existing staff, they won't squeeze in the time. So then you have to hire and train temp staff, and that has a cost involved in it. You have to put up some more equipment for them to use, and you have a lot of supervisory costs, and the people that are doing it may be inexperienced. I was talking with a head paralegal at a law firm in San Francisco. They're sending some boxes of documents out for imaging to an imaging service bureau in San Francisco, and then after that, they're sending the image discs to a service bureau in Phoenix for coding into a litigation database. This is a large law firm in San Francisco. Why aren't they doing it themselves? They figured that they should, at best, they would break even if they tried to do it themselves. And probably they're going to save money by sending it out to a service bureau in Phoenix that will do it for them. Now, let's talk about document imaging, and then we'll show you what it looks like. You can now save lots of money on photocopying costs. In typical litigation, your production documents get photocopied several times over. If you can make a complete set of copies for the other party and the other party and the other party, that adds up, and everybody exchanging boxes full of productions make the photocopy companies really rich, and your landlord doesn't mind that you're paying for all that space to stack up the boxes either. The situation is now coming to the point where document scanning and imaging is affordable. It never used to be, but in the last year or so it's changed dramatically. There are 3 law firms here in Toronto that have agreed to exchange their productions. There are 3 co-defendants. They've agreed to exchange their productions on optical disc. They've sent the boxes of documents to us, and we in turn sent them to a service bureau in the States to scan them onto optical disc, and what they have to exchange with each other now are a stack of little silver platters instead of boxes and boxes and boxes. And the benefits are that certainly the shipping time and cost is greatly reduced, what they have to hand over to each other. They're not going to be doing so much photocopying anymore. If you do want a copy, a hard copy of a document, you can print it out of a laser printer, and it's always crisp and clean. Whereas about 3 or 4 years down the road in complex litigation, when you're making a photocopy of a photocopy of a photocopy of a photocopy, it looks pretty lousy. You never lose or misfile documents when you've got an index to retrieve them off an optical disc. And when you're preparing for examinations for discovery or for trial, by searching your litigation support database looking for documents, if you're not sure whether or not the document that your database is telling you is the one you're looking for, you can have an instant look at it right there on the screen rather than having somebody go down the hall and retrieve it for you. So it even speeds you up further. It's great to have the litigation support database save you those 67 hours and reduce it down to 4 seconds to find 20 documents rather than just 15 out of 20. But beyond that, you can hit a keystroke and bring it right up to the screen to see whether, in fact, that's the document you want. And we're finished that presentation. What I'm going to do now is start up a live demonstration of imaging and the litigation support software, which we'll cover in the last 10 minutes that I've got. And that's the end of Harvard Graphics. And I commend that program to you for presentation purposes, by the way. Now, I'm switching over to my imaging software. Typing in the dark is not easy. For some of us, typing is not easy, period, but in the dark it's really not easy. Okay, I've just loaded in the imaging software, and now I'll change and load in the litigation support software. This is the sort of thing that you can automate with a menu choice on your system, so you don't have to do all these keystrokes. Okay, this is the main menu of the litigation support software, and I'm switching to a sample case that I've got in here that I use for demonstration purposes called Thénardier. You can notice, by the way, there's a whole long list of cases that I've got in here. I've got a lot of cases on the go in this little notebook computer. Now, before we get into it, I want to show you a document image and show you how you can zoom in and see some really refined detail in a way that you can't with ordinary photocopies of documents. I'm going to pop it up. And this is the imaging software that has just come up over it now. I'm going to display a diagram of the inside of a computer monitor. Now it's rotated that way for now, and I'm going to turn it around. This is a diagram that was scanned through an ordinary HP ScanJet scanner and stored on disk. And I'm going to enlarge that a little bit. And down in the lower right corner, you see the number 150031. That's the Bates number. Now, supposing there's some component of this diagram that we want to take a closer look at, say the back of the cathode ray tube, what we can do is hit the zoom box. And if, say in a product, not a product, well, maybe a product liability case or a patent case, we want to see whether that component in its finer details is an exact copy of somebody else's, we can zoom in on it. Right down to the finest wiring right there. So that's the ability that imaging gives you. Now, what we're going to do now is, we've only got a few minutes left, I'm going to give you this situation. I have a bunch of transcripts in this case, and I've got a database of about 1,800 documents in this case. And the case involves occupier's liability, where we are acting on behalf of the widow of the victim who was killed when the Phantom of the Opera brought the chandelier crashing down during the opening night performance. And he did so because he was angry that they didn't give Christine the lead role. And we know amongst the document productions that there were a number of threatening notes from this fellow named the Phantom to the Paris Opera Company. And we also know that throughout the examinations for discovery, we got the various witnesses to talk about these threats or this fellow named Phantom. So we're going to do a search of all of the transcripts and of all of the electronic sticky annotations we put in the transcripts and of all of the documents looking for the name Phantom. So I go into this mode here, and I'm going to ask it just to search for the name Phantom. I think that's an M there. Check that again. I could give it a list of other things to search for. I'm going to tell it to search all of the transcripts, and then when it's finished, I want it to jump over and search the database of documents. Let me just pop up a menu here to make sure that when it searches the database of documents, it searches every single word, every single field. It does. And we're ready to run this search. I'm going to have it give me at least one question and answer pair around the hit word in the transcript. It's also going to search any annotations I put in the transcript, and then, like I said, it's going to jump over and do the database of documents. So here goes. Let's run it. Looking in the first transcript, Viscount's deposition, there's an annotation there. Annotations come out with a little star beside them, meaning they weren't originally in the transcript. They're what the user put in. And it stops at a screen for what we see in the Viscount's deposition, something about his recalling that Christine disappeared. Then we go to Christine's deposition. So it finished one deposition. It goes to the next one. Then on into the next one, Pierre. And then into Carlotta's deposition. And then finally into the database. Okay? And so here we are in the database of documents. And I see here, let's take a look at this document here. Notice that this is pretty much giving us a printout of the sort that you would use in an affidavit of documents. The beginning number of the document, the ending number of the document, assuming every single page of the document collection is numbered. The document type, écriture means handwritten note, by the way. I use that for illustrating to my audiences in Quebec that the software manages to handle accented characters. The author and the recipient. Let's take a look at that handwritten note there a little more closely. I'm going to zoom in on it. And now, let's say, hey, I want to see the document itself, the image. I hit a hotkey, bring up the image. There it is. there's the phantom's threatening note saying, give Christine Daae the lead role or else. I'll enlarge that for you. Okay? Let's change the search now. Let's say we're more interested in the word threat. Threat or threats or threatening. Let's run that. Again, there's something in Christine's. Anything in Pierre? No. Carlotta? Okay, here's a question and answer pair from Carlotta's deposition. There's the there it is there, and there's the word threat right there. If I wanted to see more of that transcript, to see what followed right after her answer there, I can zoom into that and see the rest of the transcript. Browse around in it. See that I've got some annotations in there with the musical note symbols. I could put in other annotations if I wished. Go back here and let it run through and finish its search. And once again, once it's done the transcripts, it finds a number of hits in the database. Again, once again, let's take a look. Let's see this, a check. Zoom in on it. Catch the image. There's a check. Let's rotate that. And we see that 6 days before the disaster, the Paris Opera Company wrote the Opera Ghost a check for $1,000. You can enlarge that. Oh yeah, that's the controller's signature. No denying it. Okay, anyway, I'm going to wrap this up now. I'll just finish by saying that I've been in various places through the U.S. on business in the past little while. In New Orleans, I came across a store in the French Quarter called Marie Laveau's House of Voodoo. And they had these do-it-yourself voodoo kits on display. And one was to bring you wealth and great fortune, and another one was a voodoo kit to bring you happiness in your love life. And the third one, and there were only 3 of them, is the executive voodoo kit with the title on it, Other Attorney Be Stupid. And so this is a voodoo kit to cast a curse on the other lawyer. There's candles, and there's a little doll here, and there's some pins and some oil, and a 1-page memorandum of instructions. So the learning curve is not that great with this. I mean, and it's only $16, which is like 1% of what software costs. So it's a possibility too. Thanks very much.
That computer program was so brilliant it could integrate characters from Les Mis into Phantom of the Opera. Well, that's a given, 100%. You cannot operate these days without a computer system. Our next speaker has got to be included in any list of the country's top litigators. If you're asking yourself who are the best litigators in the country, Ian Outerbridge is on everybody's list. He's been everything. He's been president of the Bar Association, he's been bencher. He was one of the first guys to teach us all about office management. He's the expert on how to investigate, how to find experts. He's published lists of experts. He does regular surveys on experts. Mr. Everything, Ian Outerbridge.
Until I saw that voodoo doll, I thought I was going to be the only person on this program talking about how to do it cheaply. And I'm flattered to be on the program, I must tell you, because that's not my reputation. I have another quick cure remedy to doing this cheaply. My friend sells voodoo dolls. I sell textbooks. And the textbook I'm going to commend to you is a book called Sun Tzu and the Art of War. Now, Sun Tzu, this is a very thin book. It's only got 13 chapters in it. Some of the chapters are only 1 page long. It's the kind of book that you and I like to read. Sun Tzu lived in 500 BC, and he was a very famous Chinese military strategist. His works were really not accorded too much recognition until the Vietnam War, when they discovered to their amazement that every time they found the body of a Vietnamese officer, he had a copy of Sun Tzu and the Art of War in his pocket. And when they started to study Sun Tzu and the Art of War, they discovered a rather striking phenomenon, and that is a great deal of Mao Zedong's Little Red Book is plagiarized from Sun Tzu. At which point they became a little more interested in Sun Tzu, and they discovered with some interest that it was the principal textbook used by the Japanese War College in training of officers in World War II. Needless to say, it is now used as a textbook at West Point. You people are inclined to put military people down today, and I only mention this to you because do not be put off by the title Sun Tzu and the Art of War, because we as litigators are very truly engaged in warfare in Sun Tzu's context. Now, we don't kill people or slaughter them on the battlefield, but we are engaged in the resolution of conflict, and we are engaged in the strategies of conflict, and you will be surprised to discover that Sun Tzu, writing in 500 BC, has an awful lot to say to lawyers who are litigating in the year 2000. One of the things that Sun Tzu makes very clear is that knowledge is the sole instrument of warfare. Sun Tzu says that if you know your enemy and you know yourself, you will triumph in 100% of your battles. But if you do not know your enemy and you do not know yourself, you will lose 100% of your battles. And if you know yourself but do not know your enemy, you'll only win 50% of the time, and vice versa. I've often heard it said that litigators always only win 50% of the time, and speaking for myself, I would like to win 50% of the time, which gives you an indication of the amount of knowledge that we really possess when we go into trials. The fact of the matter is, knowledge is everything, and that's what we're talking about this morning. We're talking about investigating and how to do it cheaply. So the first thing I suggest to you is buy a copy of Sun Tzu. It will pay you enormous dividends and will certainly teach you a few things about investigating. Sun Tzu has a chapter in his book called The Use of Spies. This is a very interesting chapter, and curiously enough, Marlis Edward tells me that when the Scientology guardians were arrested, they discovered that in the bottom drawer of their desks was a book called Sun Tzu and the Art of War. And the section on spies was very heavily marked up. Sun Tzu says that there are four types of spies, living spies, local spies, turned spies, and expendable spies. Now, if you are a student of the genre of spy stories, you'll know that spies are people that sneak in and infiltrate and look for secrets, etc., etc. But the fact of the matter is, as Sun Tzu uses the words, they have very real meanings to you and us today. The living spy, for example, the living spy is the person who saw something, the eyewitness. The living spy is the private investigator that you hire to go out and inquire. The local spy, in Sun Tzu's parlance, is pretty obviously the expert. He's the guide, the person who has been there and knows what it's all about. The turned spy and the expendable spies really do exist. They're the people that come to you with the smoking gun. They're the former employee or the ex-wife. They're the people who are involved and are prepared to squeal. The expendable spy is the spy that you're prepared in John le Carre's novel. Most of his spies are expendable. They're the guys that never get back. They're shot as they go across the border. The expendable spy is the person who comes to you and wants to help, but you know they're really in the other person's camp and they really aren't going to help you at all, so you fill their hat with all sorts of useless information which they take back to the other guy and confound him completely. Now, you say, Mr. Outerbridge, do those things really exist? And the answer is yes, they all really exist. So I say to yourself, buy Sun Tzu, and remember his famous statement that the acme of a good general, and this is true of lawyers, the acme of a good general is not the man who fights 100 battles and wins 100 battles. Not at all. The best general wins 100 battles without fighting any. And you can only do that with knowledge. Okay, you have a paper from me that tells you how to do it, but it doesn't tell you who to do it to. And so I'm going to talk just a little bit this morning about who to do it to. Now, Harvey told you about his interviews with the client, and that's, of course, the place you start. You have to have a story. You have to have something that you want to find out about, and you get that from your client. As a general rule, we are trained in law school that hearsay is something to be excluded. In this interview that you're going to have with your client, hearsay is to be encouraged. Do not ever block the hearsay. Let the people talk. Let them talk, and listen. The role of a good lawyer at this juncture at the beginning of a case is to keep his ears and his eyes open and to shut up. Listen to what your client's telling you, because it's from the source of your client that you're going to find out, A, what the case is all about, and B, who it is that is likely to know something about the case. After your clients stop talking, you can start asking them questions. You can start asking them questions of the ordinary kind: who, where, why, what, when, how. And from the answers to those questions, you will find the names of people or the things which will assist you in improving your case. So far, you haven't spent any money now. You're just listening. You want to know who overheard anything. And it's so often and so common that people never ask the question, who was present when that happened? Who overheard or who watched? Then you want to know and have some explanation of the events. Now, these are very general statements, but it's very hard to give you an investigation into every fact situation. So I simply say to you, you want some explanation of what happened that is consistent with common sense. Do not forget that it isn't how clever you are that wins the case. The court has to want to help your client, so look for a reason. Look for a reason as to why the court would want to help your client. That's the crunch of your case. If you can't come to a conclusion as to what reason would motivate a court in doing something for you, you've got a very bad case. Once you've come across that reason of what will motivate the court in doing something for you, then set about asking yourself, well, now, if that's the reason, how do I go about demonstrating factually in the courtroom that that reason exists and that it's in favor of my client? And that's where you're looking for explanations. You want to explain what happened. You want to understand what happened in a context which is favorable to your client. You desperately need an understanding of what happened. Without that, you cannot direct the investigation. Now, at this juncture, you will find two things are immediately necessary. One is you have to go to the law books, and the second thing is you need an expert. Not as an expert witness, but someone who can help you in your understanding of the facts that you've just had played out to you. Unless you have a very eclectic background, the odds are that the facts that are being played out to you are something that are beyond your ordinary experience, and so you're going to need somebody who is experienced in that area who can listen to those facts or have you play the facts to them, and they can give you some understanding or teaching or training so that your comprehension of what's involved is clearer. You have to get to the law books because while you think you've got your cause of action, you've got something formulated, you've got some tenuous ideas, and I don't care how long you've been at it, you're always back at the law books at this stage. You want to know what facts are required to prove that case for the plaintiff or to prove that defense, or what other defenses are available to you, but essentially what facts are required, because the facts control the law. Without the facts, the judge can't do anything for you. So you may have a great case that's compelling. There's no real doubt in the world that the judge is going to want to help you. But if you don't give him the law that's going to enable him to help you, you're not going to win, and you're not going to be able to give him the law unless you've taken the trouble at the beginning to find out the facts which will support that law at the end. So in that preliminary canvas, you identify A, the understanding, and B, what facts you require. Now, we're not talking about what facts you've got. We're talking about what facts you require to win. And then you say, okay, now, where would those facts be? And then you start the treasure hunt, because now you know what facts you have, and you have to figure out how to find those facts and where they would be if your case or the case you're going to advance is true. Now, to understand that, or at least to go for that, you then have to sort of start asking yourself some questions, because we move into an area of proof. Sometimes it's easy. Sometimes there's an eyewitness. Sometimes you're absolutely certain as to who those people are going to be. But sometimes it's not at all easy. And at this juncture, I commend to everyone a third thing. You've done a little bit of legal research. You got yourself an expert. For heaven's sakes, go and look. If it's an automobile accident, go to the scene of the accident. If it's a crime, go to the scene of the crime. If it's a manufacturing plant, go to the manufacturing plant and see how the damn thing is made. Go and look yourself. Because the moment you go and look yourself, again, your comprehension of the problem is perfected. Again, your understanding of what the expert's telling you is now clearer. And believe me, it happens every time, and all of a sudden, oh, that's what he's talking about. Yeah, well, all right? You don't, until you see it yourself, you don't understand it. And thirdly, at the scene of whatever it is, you see things which provoke your curiosity. You say, what's that? Or, how does that work? Or, what does that do? Or, gosh, I didn't realize there was a tree there. Give you, for instance, yesterday, I'm in the process, I'm always in the process of moving people around. I'm moving people into an office. And the discussion related as to what office a particular person should be in, and it was clear on the floor plan she should be in X. Until you went and looked at X, and when you went to look at X, you saw that the eaves came down in such a way, I live in an old house on Jarvis Street, that her equipment couldn't fit into the room. Somebody tells you something, everything makes sense, it all fits, the plan's perfect until you go and look at it, and when you go and look at it, you discover it can't be. It just can't be that way. So it has to be something else. So often, the best laid plans go down the drain with a good photograph or a good visit to the scene. And you also have to know whether or not that invitation to take the judge to the scene is something you want or something you don't want. So right at the beginning, you may go again, you may go 3 or 4 times, but right at the beginning go, because what's that? That little idea, that little bit of curiosity may point you to the very witness you're looking for. Okay. Now, with all of that together, you start asking yourself, if my theory is correct, who must have been present? Forget about what you've been told. Who must have been present? Can that happen in the absence of somebody knowing about it? And if somebody must know about it, who must that person be? And he's your witness. If that person did such and such, who would have been affected? And that person may be your witness. How would they have reacted? And toward whom would they have reacted? That person may be your witness. How would their friends perceive them? Go and find their friends. How did you perceive them? Look for the person that must have made the observations, even 10 years ago. We were trying recently to find someone who had made the observation of a person 10 years previous. And every time we found somebody that knew this particular person, gosh, 10 years is a long time ago, gosh, I don't think I can be of help to you, gosh, 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 we couldn't get a witness if our lives depended upon it until we found out that the young lady in question was taking a course of chiropractic therapy during the whole period. So we went and saw the chiropractor, and we got out the chiropractor's notes, and you know what? There's no mention of anything having happened. Right straight through the period, including the day of the so-called accident and the day after the so-called accident. Think about that for a minute. All you have to do is focus on what evidence it is that you want. What must it have been? All right. Remember when you're interviewing eyewitnesses that you're looking for something else, because you're not only looking for witnesses who will testify to things, but you're looking for demonstrative proofs, you're looking for documents, and you're looking for pieces of evidence. Now, I always approach this on the basis of something which you're all familiar with if you have children, and if you're not children, you're still familiar with it because you probably remember it in your own experience. But in kindergarten and in grade 1 and 2, they used to have a program called Show and Tell. Everybody here should be familiar with Show and Tell. Well, Show and Tell is essentially the theory of demonstrative proof. Think about it. I believe such and such is true, and by the way, I also kept a note of it, or I kept something. Aha, what do they keep? What is it? What souvenir did you take? How do you know what you say is true? Well, I know it's true because I marked it on such and such. Where is it? Now, that is what I would call accidental demonstrative proof, but always ask people how they know something to be so. How do you know that's so? And you'd be surprised the number of times they say, well, I know it's so because I took a picture, or I know it's so because I kept the shirt, or I know it's so because, and the because really and truly speaks more loudly than the words that they use. Recently, a case involving a man who was, the argument was he never entered the particular room. The room had green dye dripping from the ceiling. He never entered the particular room, and his wife was able to produce his underwear shirt with the green stain. Think about it. Why do you know that it happened? If you have a private investigator, and I'm now just on the point of stopping, Harvey, you'll be delighted to know I'm going to get you back on target. If you hire a private investigator, for heaven's sakes, these people are very valuable. I use them all the time. I have a couple that I employ. But if you use them, you don't hand them your file and say, here, Charlie, I got a new case, go out and investigate it. If you do that, you'll get a report that says, I went to Mr. So-and-so's house, I parked my car, I sat outside the car, outside his house from 7 o'clock until 7 o'clock in the morning, and I listened to the radio, and nobody appeared. Yours very truly, Charlie Brown. Utterly and totally and completely useless. If you hire an investigator, you say, I want you to interview Miss So-and-so. I want you to interview Miss So-and-so. She works at the such and such a place, and this is the evidence that I want from Miss So-and-so. If she can't say that, make sure you've got it down in writing that she can't say it. If she can say it, get it down in her words. In other words, the investigator is a pair of legs for you who goes out and gets you the evidence you're looking for. You tell him what you want, and you send him specifically to go and get it. Now, sometimes you have to give them a little more discretion than that, but it isn't much wider than that. In the automobile cases, you'd send an investigator out to the scene of the accident to take a look at the scene of the accident. And he would come back with a diagram, he'd come back and show you where the skid marks were, he'd have the list of the witnesses who saw the accident, and if he was an industrious investigator, he'd go out and he'd obtain a statement from each of the witnesses who was at the accident. But that's pretty specific, and it's pretty generic. In a complex case, that investigator is not going to know what facts are of importance to you. Only you know that. You know that from the understanding you acquired at the beginning and from your look at those law books. Thank you very much, Harvey.
Thank you, Ian. 10-minute break. Come back quickly.